Welcome back. The Minerals Council of South Africa has scored a critical victory after the Pretoria High Court ruled in its favour against the Mineral Resources and Energy Department. The court has ruled that the Mining Charter is an instrument of policy and that Mineral Resources and Energy Minister Gwede Mantashe is not entitled to make law through it. To help us unpack that ruling, we're joined by Daily Maverick's Stoddard. Ed, thank you so much for making time. You have described this ruling as a judicial smackdown of note against the department. What does this judgment boil down to?
Yeah, hi, good afternoon. So one of the things it boils down to is at least according to the Minerals Council, that it brings some much needed clarity to policy in the sector. So basically, the judgment removes clauses dealing with the renewals of existing mining rights and the transfer of mining rights, which compelled companies under the 2018 charter to keep topping up their BEE shareholdings. So for example, if you were a company that made the 26% threshold of black ownership, and then some of your black shareholders sold their stakes, so you got down to 18%, say. The wording in the charter was that you would have to perpetually keep topping that up, and this basically this court ruling basically holds that once a company is empowered, it is always empowered.
But doesn't that then take the industry back in terms of transformation? What happens then when, for instance, empowerment holders sell their stakes and the companies then start falling below the 26% threshold?
Well, that's an interesting point. But I suppose, for one thing, the industry would probably argue that what's the sense in having a stake in a company if you can't transform it into capital? Right, so that you know right? If you're a black shareholder, will you never be able to sell? That would be egregious in some ways. And the other thing is, then for companies, the thing is, if they have to keep topping up, that can be expensive, very costly actually. And so after a while, if you have to keep repeating the exercise, especially foreign investors, for example, will just say no way.
So
you're not going to get any fresh investment into the thing is, it's seen as a significant deterrent to investment into the sector.
I see. Do you think the department is going to appeal it?
I don't know. They put in a brief statement earlier today saying that they're still studying the judgment. So that is part of the problem here in South Africa, as you're well aware, that the society here is very litigious. So these things can get snarled up in court for years and years and years, right? Before there's final clarity.
Yeah. How did the department justify? Yes, Ed, go ahead.
Well, sorry, Clement. I was just going to say the judgment also said provisions around the procurement of goods and services, right? That mining companies said were unachievable.
Yeah. So,
for example, local procurement, a target might be, say, 60% or 70% or something like that. But some of these companies, they have to import a lot of capital equipment, for example, and they have to import it. It's just not being made here, right? So, I think the industry would say that it supports transformation, obviously,
Yeah, all right. Ed, thank you so much for making time. Ed Stoddard is a journalist with the Daily Maverick who focuses on issues around mining. Now, here's a reminder.